Well, the Constitution was finally ratified and the new government went into effect in 1789. But as you recall from last time, James Madison had promised to address some of the really legitimate concerns that Anti-Federalists had raised about the document, specifically that it did not have a declaration of rights for individuals. So therefore, Madison had promised that he would get right on that, essentially, and he was in the House of Representatives, and he did, in fact, draft 12 amendments to the Constitution that would constitute a Bill of Rights, and was entered into to Congress to begin the amendment process. That was Madison's action. Alexander Hamilton, and this may surprise you, Alexander Hamilton was opposed to the idea of a Bill of Rights. But it's not because he didn't think people should have rights. It's not because he didn't think people's rights should be guaranteed. It was because, and Hamilton wasn't the only one who felt this way, it was because he feared that if you were to make out a list of all the rights that individuals have, natural rights, unalienable rights, what if you forgot one? Or what if circumstances changed and something began to be considered a right that might not be considered a right at that time? So by making a list, you were therefore rendering finite the number of rights, natural rights, a citizen had. So that was his concern, and Madison found a way. He found a way to deal with that as well. So he had 12 articles in his proposal. Madison did. The first 2 did not pass, and we'll look at those later. And then the next 10 did. So the Bill of Rights is the first 10 amendments to the Constitution, which were all entered in together in late 1789, and went through the whole process of being ratified state by state, and finally were finalized and ratified in 1791. So Madison kept his promise. That was essentially the first thing that Congress jumped on and got done. So what I would like to do for the next several minutes is take a look at those 10 amendments to the Constitution, the first 10 known as the Bill of Rights, and talk about each one at least a little bit in turn, because it's very important as a citizen that you know what your rights are. So here we go. The First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So the First Amendment actually covers a lot of stuff. You've got freedom of religion, freedom of speech, freedom of the press, and freedom to assemble peacefully, and freedom to petition the government when you have a grievance. Now, notice what it said about religion. Congress shall make no law respecting establishing a religion or prohibiting a religion. And I will refer you back to the discussion we had earlier about the concept of separation of church and state and how that came about. All right, the Second Amendment. A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. The Second Amendment. Bet you've heard of that one. A lot of people really focus on that one to the extent I think that they forget about the 9 others. But be that as it may, the wording of this amendment really should have been clearer, because it has left things open in time to interpretation. It's entirely possible and probable that people had a specific understanding of it when it was written. But there are a lot of different ways to look at what this is saying. One way of looking at it is that what this says is that a well-regulated militia, that means trained, a trained militia, which is what today we call the National Guard. Each state has a National Guard. The militia is necessary, so it is a right of the people to be in the militia, and so that has to be protected. They have the right to be in a well-regulated militia. So that's one way of looking at it, that this really just means that states should always be able to have a National Guard. Another way of looking at it is that the right of people to have weapons, arms, should not be limited or infringed on because they might need those arms to go join a militia. That's the other interpretation. In reality, those well-regulated militias early on, starting at the very beginning, were under the control of state governors. So this is not like an ad hoc militia that it's talking about. But nonetheless, that's another way of looking at it. You can't stop me from having any weapons I want. That's the other way. That's the two extremes, and there are various other interpretations that lie in between. And because the language is so vague, it could be read to mean either thing. The official Supreme Court, the most recent Supreme Court interpretation, as of 2020, of the Second Amendment is that it means you cannot be prevented, you cannot be denied the right of owning a handgun that you keep in your home. It's that specific. Does that mean, does that apply to any type of gun? Does that apply to the number of guns that you have? Does that apply to whether or not you have the right to carry them around openly in public? Those are things that continue to be argued about. So still, a bone of contention. I say still, it's actually only been probably in the last 50 or 60 years that it has been a bone of contention in the United States. All right, Amendment number 3. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Well, wonder where this one came from. No citizen can be forced against their will to let soldiers live in their house. Well, of course, that's what the British had been doing, right, back in Boston, remember? So that can't be done in times of peace. And what was happening in Boston was during times of peace. But notice, during time of war, that can happen, as long as it's in a manner prescribed by law. So particularly in the Civil War, when all the fighting was taking place in the United States, there was a lot of this requisitioning, basically taking over people's houses, turning them into hospitals or turning them into barracks. In fact, my hometown of Sparta, the church that I attend, Sparta First United Methodist on Church Street in Sparta, congregation has been there since, I think, the 1830s. During the Civil War, Union forces turned that church into a stable and used part of it as headquarters while they were occupying the town. All right, number 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So, number 4, unreasonable search and seizure. The government, according to this, doesn't have the right to just start searching your home randomly from out of nowhere with no reason. They have to have a warrant. And in order to get a warrant, they have to go to a judge, and they have to lay out a specific reason that they should search your house. And then that warrant will say specifically what they're allowed to search, and they can't go beyond that. This is the kind of thing that was done regularly also by the British during the colonial period. Just like, grabbing people off the street and taking their stuff, or going into their house and ransacking the house looking for things. Number 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The Fifth Amendment, there's a lot of stuff in there. Number 1 there in the Fifth Amendment, you have to be indicted by a grand jury for a serious crime. So you can't just be arrested for a serious crime and sent straight to court. It first has to go to a grand jury who has to decide whether there's enough evidence to merit going forth with a trial. Now, you'll notice there's an exception. Except in cases arising in the land or naval forces or the militia in times of war or public danger. So the exception is if there is martial law. Martial law means law during wartime, which is where this comes into effect. If martial law is declared, then yes, you could be arrested for a crime without going through that indictment process. And you would wind up going, during Reconstruction, people wound up going before military tribunals while martial law was in effect. Here's another one, the double jeopardy clause. You can't be tried for the same thing twice. So that means that if you were arrested for murder and there was a grand jury and it went to trial, and at the trial the evidence was presented and a jury found you innocent. If 2 years later they found more evidence, that's too bad because that trial is over. You can't be tried again. Now, an exception that was created in the civil rights era was that you could be tried for doing the same thing but for a different crime, like people who had lynched African Americans and then been found guilty by a jury of their white Southern male peers could also later be charged with violating the civil rights of the person for lynching them. So that's a different crime. Nor shall you be compelled to be a witness against yourself. Pleading the Fifth. You can say that you refuse to answer certain questions because it might incriminate you. And you have the right to do that. And that doesn't necessarily mean that you're admitting guilt. Nor can you be deprived of life, liberty, or property without due process. Can't be done randomly. Nor shall private property be taken for public use without just compensation. That's called eminent domain. It would later be firmly established in the Supreme Court. In the case of Johnson v. McIntosh, was that the one? I think it was. But essentially that, yes, the government can seize your property. Let's say they're making a highway. Let's say they're making a railroad. Let's say they're creating a dam. They can take your property, but they have to pay you for it. They have to give you just compensation. Now, that's where it becomes an issue. You might not want to sell your land for any price, but if the government wants it, they can take it. And Who gets to decide what just compensation is? Well, essentially the government. So that is the eminent domain. Fifth Amendment, just like the First Amendment, a lot of stuff in there. Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to having the assistance of counsel for his defense. Now, this is all about being prosecuted for a crime, but there's a lot of stuff in here too. You got the right to a speedy trial. They can't just, and this is something that used to happen in Europe, they can't just arrest you and then not have the trial and just leave you in jail waiting trial for years and years and years. You have the right to a trial by an impartial jury, which is why, if the jury has been, quote, tainted by the jury members having been exposed to stuff that might prejudice them for you or against you, then they have to get a new jury. Same district where it was committed, you have to be informed of what you're accused of. So you can't be arrested and you say, what am I being arrested for? And you're told, shut up. They have to tell you what you're being arrested for. They also have to confront you with the witnesses. So unlike in some countries, a witness can't go to the police and say, I saw so-and-so, and then the person be arrested and never told who had testified and never seeing their testimony. Also, if you're arrested, you have the right to compel witnesses in your favor. So if there are people who could testify for you, then the court can order them to do so because you have that right, whether they want to or not, essentially. And also you have the right to an attorney, the assistance of counsel. Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Now this is sort of like the forgotten amendment. No one talks about this one on episodes of Law and Order or CSI or anything like that. Essentially, you have the right to sue somebody if they've caused you to lose money. As long as it's over $20, you have the right to demand a jury trial, a jury hearing of your civil suit trying to get money. Now, you may do that because you may feel that you could persuade a jury better than you could persuade one judge. But it's important to bear in mind, this pertains to federal court. This doesn't pertain to state court. So states might recognize this and they might not. They don't necessarily have to, but anything done in federal court does. Only about 1% of civil suits take place in federal court under this type of circumstance. And also, if you, just like with a double jeopardy, if you're sued in a civil suit and there's a ruling, you can't be sued for the same incident again. All right, number 8, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, the last clause, cruel and unusual punishments, that kind of like the Second Amendment, is something that can change over time, or is not specific and clear enough, really to cover everything. Because what is considered cruel and unusual? A lot of times it depends on the time period, right? So during that time, you could not be drawn and quartered like the English used to do, where they would cut your guts out, and castrate you and stuff. This would also, in the United States, eventually be applied to certain other types of execution. But then some types of execution haven't been allowed. Some people will argue execution itself is a cruel and unusual punishment. Some people would argue that lethal injection as a means of execution is cruel because it's very painful, or electrocution. So that, again, it kind of depends. The first part, there's a strong argument that could be made that a lot of places in the United States have forgotten about this one. Excessive bail is a big problem. People being arrested for relatively minor things and then having fines imposed that are far beyond their means to pay, which means those fines get compounded, and it makes things worse and worse for them, and then they wind up getting arrested again for not paying their fines. So that's the sort of thing, actually, I think needs to be examined more. Now, number 9. This is put in there for Alexander Hamilton and people who agreed with his way of thinking. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So it specifically says the fact that we list out a number of rights doesn't mean these are the only rights that people retain and can have. So that was Hamilton's big worry. There are some things that the Supreme Court, has kind of codified and enshrined that are not initially in the Bill of Rights, like the right to privacy, for example. Courts recognize that, but that's not in the Bill of Rights. Finally, the 10th Amendment. And this is basically to define that federalist system and to address those people who are concerned about the rights of the states. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. So what that says is that anything the Constitution doesn't specifically say that the national government or the federal government has as its jurisdiction, then that's in the court of the states. That's why a lot of laws, whether it be drinking age or speed limits or whether you can carry concealed weapons or whatever, varies from state to state. Those are the 10 amendments that make up the Bill of Rights. What about the other 2 that didn't make it? Article 1 basically laid out a sliding scale for how many representatives there could be. And it's very specific. It's like, it gets compounded as the population goes up. But the purpose was to guarantee that each congressperson in the House of Representatives represented a relatively small number of people. And the reason for that was that Madison believed that an effective congressperson needed to understand the problems of their constituents. However, that one never got passed, and if it had been passed, today we have 435 members of the House of Representatives. We might have 1,500 or 2,000 if this had been passed and set up in the way that it was intended. Article 2 stated that any change in pay for Congress, I said here pay raise, but also taking away pay, any change in pay for Congress that Congress votes on cannot take effect until after the next election, so that you wouldn't have a situation where congressmen or congresspersons, congresswomen, are voting for a pay raise that they're going to immediately get. Instead, It has to be a situation where they're voting for a pay raise for whoever happens to be in Congress next time, which might be them and it might not. That one also didn't pass, but almost 200 years later, it went out to the states. But they never got around to voting on it. And almost 200 years later, a college student, a 19-year-old college student at the University of Texas, learned about this in one of his classes and wrote a paper. And in his paper, he argued that because it had never been voted on, it was still active and still could be voted on. And his teacher gave him a bad grade because he thought that was ridiculous. And then the student got kind of ticked about that because he thought he was right. So he went on this big campaign getting publicity. And turns out the student was right. The student was right. This had never been voted on, so it still could be voted on. And then it was voted on and passed and became the 27th Amendment to the Constitution in 1992. The 27th Amendment is the most recent. There are 27 amendments in all as of 2020. So you got this really weird situation where the newest amendment to the Constitution was actually the first one that had been proposed. Well, with all these amendments and with this Bill of Rights, anti-federalists were generally satisfied that the rights of the individual were being looked out for. And so now the incident that occurred at the end of the original Philadelphia Convention to draft the Constitution has kind of been fulfilled, because even though Madison wanted these 10 amendments not to be amendments but to be added into the body of the Constitution, and instead they were tacked on at the end, either way you look at it, this kind of completed the Constitution at that time, although there have been 17 more amendments since then, so it's a living document that can still be changed. But that really harkens back to what Benjamin Franklin said when he walked out of that building in Philadelphia when they had drafted this Constitution, and a bystander, I think it was a woman, called out to him, "Well, doctor, what have we got? A republic or a monarchy?" And Franklin famously replied, "A republic, if you can keep it." So that's an important distinction. From the very beginning, Franklin and others recognized this was a fragile thing that had to be protected, had to be sustained, and it required vigilance. It required constantly paying attention because it could be undone.